there was no substantiation of the allegations in the CIT.
This matter is before the court on the defendant's objection to the ex parte order and motion to rescind order and for make-up parenting time. Mr. Sullivan.
The objection, which we filed on or about July 25th, 2024, speaks for itself and lays out the basis upon which the objection has been filed. Nothing in the allegations that we've advanced in that objection are any different today than they were at the time that we filed it. I would indicate that I talked to Delon Williams, the CPS worker, this morning, who again reiterated that there is no formal safety plan in place, but she did tell me and suggested that pending the closure of their case, and I didn't indicate in the objection that their case was actually closed, but there was no substantiation of the allegations in the CIT, that pending their case, she would recommend that when the parenting time occurs, that my client not bathe the child, not dress the child, or those types of things, or sleep with the child. And we would add, as a measure of safety, that the grandmother, Letitia, will agree to be present at all parenting time. So again, no allegations have been substantiated, and those would be fair measures to put in place, and we would agree to them.
Mr. Murphy, have you had confirmation from Mr. Williams that CPS is basically not substantiated the case, not taking any action, nor is there any other forensic interviews or anything else to be conducted?
I spoke with a different CPS worker who indicated that the investigation is still ongoing. It is also my understanding that at the interview, the child did not disclose what happened. However, since this objection was filed, the child did disclose what happened to a healthcare worker. It was a nurse and a doctor during an appointment. I have not received any information from CPS as to how that'll affect their investigation. As of right now, my understanding from CPS is the investigation will remain going and a report may become available August 19th. That may be when it is closed. However, that was before the new information of the disclosure to a healthcare worker. So it is unclear right now exactly where the report will stand or when it will come out. What we do know is she has began to disclose the information to medical professionals.
Okay.
May I intervene, Judge?
Yeah, go ahead, Mr.
Ms. Williams was aware of a disclosure to a healthcare worker, but that was followed by a non-disclosure to the medical provider that works in concert with the healthcare provider. The healthcare provider, as you know, interviews the child first, and then so does the doctor, and the disclosure was not made to the doctor. So the idea that the child is now beginning to disclose is not an accurate assessment of what's occurred. And Ms. Williams, the CPS worker, was aware of what was just put on the record, and those are the safety measures that she thinks would be appropriate at this point with parenting time.
Okay. Mr. Sullivan, what was the missed parenting time? I didn't have a number in the
Well, there was missed parenting time in the spring, but the missed parenting time recently, the parenting time that my client receives is visit every Monday from, I think, 5 to 8 or 5 to 9, every Wednesday overnight, and then every other weekend. So the weekends that were missed were July 5th, July 19th, and August 2nd, as well as the Wednesday overnights that occurred between that time, as well as the Monday non-overnight visits.
So we have 6. So we might have 9 or 10 overnight.
About 10 overnights, I would say.
Okay. Mr. Murphy, Mr. Sullivan has proposed that apparently the paternal grandmother would be involved so that and have a provision where his client wouldn't bathe, dress, or sleep with the child, but apparently that the paternal grandmother would be present for purposes, I guess you'd say, of supervising the parenting time.
The concern with that, Your Honor, is the fact that the paternal grandmother was there at the time these allegations took place. So there's concern whether or not that'll actually do anything at all to protect the child. As far as a long-term solution goes, some of the information that was provided by that CPS worker may be very helpful. But right now, with an investigation that's still ongoing, combined with the fact that, the minor child is meeting with a therapist who is recommending that having contact with the defendant at this point would be destructive to her processing of the trauma that she's endured and going through that. So with that, keeping the ex parte order in place while that investigation occurs is something that will be protective of the child. And as for long-term solutions, that's something that can be addressed once the investigation is closed.
Well, if Ms. Williams states that there's not substantiation, they can say it's ongoing, but that's only until such time as they get the report completed and dismiss the case. It doesn't mean that they're actually doing anything at this particular point if they have not substantiated it. So I don't know by saying that, well, there's still ongoing investigation, that has any credible impact upon the case.
And it's very possible, Your Honor, and the difficulty with the CPS case is with it ongoing, they will not provide any information as far as the reports go. So it's very possible that you're correct in that they have made their determinations and just not issued the report. The problem is we just don't know.
Last word on my objection.
Yeah,
On my objection. Ms. Williams said there is no need to have a safety plan at this point. She says that she would recommend, and we would agree with those various provisions that I indicated. And we added the condition that Ms. Rodriguez, Leticia Rodriguez, be there as well.
Okay. Well, what the court's going to do is it does appear based on what Mr. Sullivan has provided, and court notes he is a officer of the court. Court will accept him as his word. And speaking to Ms. Williams, the court is going to vacate the ex parte order, and court will allow makeup time of 10 overnights with the conditions as Mr. Sullivan delineated, that again, the maternal grandmother be present, that the defendant would not bathe, dress, or sleep with the child. And I think that provides sufficient protection if in fact something changes with the CPS report when it's done. Mr. Murphy, you can renew your motion or renew the request for the ex parte.
Yes, Your Honor.
Okay.
Your Honor, would the court have any counsel with regard to how the overnight makeup time would occur?
Well, what we can do, I don't know if this upcoming weekend is, or upcoming Wednesday or upcoming weekend is one of his regular parenting time. Well, Wednesday would be, correct, Mr. Sullivan?
Correct.
Okay. And what we'll do is this coming weekend the weekend of the 9th? Is that his weekend?
No, it's the following weekend, Your Honor.
Why don't we do this, is we will start the makeup of the 10 days, start August 9th. And so he'd have you do Friday at 6 through Sunday at 6. And then he would have the next 5 weekends that are hers to make up his particular 10 days of parenting time.
Understood.
Okay. And Mr.
Thank you.
Selvin, you can incorporate all that into the order.
Thank you very much.
Okay, thank you both. You have a plaintiff's motion for reintegration of the child and remove parenting time conditions.
13 months ago, there was a no contact ordered between, at the time, 5-year-old Jacob Vandermeer and Kelsey, 4 years old at the time. No one has found that Kelsey was in fact assaulted, period.